Quick question. You ever just turn on your phone's location tracking without really thinking about it?
Yeah. Google Maps kept asking me to, so eventually I just hit OK to make it stop.
Right. You hit OK, you move on with your life. But here's the thing. When you did that, you handed Google a record of everywhere you go, every 2 minutes, for as long as that feature stays on,
Which I promptly forgot about.
which everyone forgets about. And that forgotten choice is sitting at the center of one of the biggest Fourth Amendment cases the Supreme Court will decide this term. That's basically what we're talking about today in Chatrie versus the United States.
And the stakes are genuinely enormous. Think about this. The government can draw a virtual fence around a location, a bank, a church, a political rally, and order Google to identify every person whose phone appeared inside that fence at a specific time.
No specific suspect, no name, just find everyone who stood there and tell us who they are.
Wait, so law enforcement can compel Google to search through the accounts of hundreds of millions of users just to find the handful of people near a crime scene?
That's the exact question. And what the court answers will determine whether geofence warrants, a tool police now use regularly, survive the Fourth Amendment.
Welcome back to the High Court Report. Today we break down Chatrie versus the United States, a case that asks whether Google's location data on your phone belongs to you, or whether the government can compel Google to search it without ever naming you as a suspect. The Supreme Court will hear this hotly contested case on April 27th. Quick reminder, please follow, rate, subscribe, share, and review the podcast on Apple, Spotify, YouTube, anywhere you podcast. Just search the High Court Report.
And look, if you've ever hit OK on a Google prompt without reading it, this episode might make you regret that, or at least think twice. Questions about this case? Reach out to us via LinkedIn at the High Court Report. All right, here's what you need to know. The formal legal question, whether the execution of the geofence warrant violated the Fourth Amendment.
Okay, in plain English, that means, did police break the Constitution's rules against unreasonable searches when they ordered Google to dig through the private location records of millions of users, rather than targeting a specific person's account to figure out who robbed a bank?
And to understand why that question matters, you need to understand two things about the Fourth Amendment. First, the government can't conduct unreasonable searches. Second, any warrant the government obtains must particularly describe the place to be searched and the things to be seized.
That word, particularly, ends up doing a lot of work in this case, because a geofence warrant doesn't name a particular account. It tells Google, search everything, then tell us what you find. And the Constitution says you need probable cause, a solid factual basis, that evidence will be found in a particular place before you search. The question is whether a particular place can mean every Google account in existence. Let's back up and talk about how we got here.
The timeline on this one, it's wild.
How wild?
Armed bank robbery to convicted felon, identified entirely through a phone's forgotten location setting. On May 20th, 2019, at about 4:50 in the afternoon, Okello Chatrie walked into the Call Federal Credit Union in Midlothian, Virginia, apparently talking on his cell phone. He handed a teller a note. "I've been watching you for some time now. I got your family as hostage." When the teller said she didn't have access to the amount he demanded, Chatrie pulled out a silver and black firearm, ordered everyone to the floor, marched the manager to the vault, and forced her to fill a bag with $195,000. Then he walked out. Detective Joshua Hilton responded to the scene, reviewed surveillance footage, and noticed the robber appeared to be on his phone when he entered the bank. Over the following weeks, the investigation stalled. No suspects, no leads. So on June 14th, 2019, about 3 weeks after the robbery, Detective Hilton applied for what's called a geofence warrant. He drew a virtual fence 150 meters around the bank, a circle with a radius longer than a football field, and asked a Virginia magistrate to order Google to identify every device that appeared inside that fence during a 1-hour window around the robbery.
And how many accounts did Google search to answer that question?
Every single location history account in Google's database. Hundreds of millions. Google internally called that database the sensor vault. The system recorded location every 2 minutes, down to within 3 meters of a device.
And what came back?
19 unique devices. Then, through a 3-step narrowing process. First anonymized data, then extended anonymized movement data, then finally, names. Investigators zeroed in on one device. Its movement pattern, it appeared inside the geofence before the robbery. then headed away toward a residential neighborhood. That device belonged to Chatrie, who, it turned out, had enabled location history 10 months earlier and never paused it, including during the robbery.
Follow-up searches of Chatrie's home found nearly $100,000 in cash, still wrapped in bands signed by the victim teller, 2 robbery-style demand notes, and the silver and black pistol.
Chatrie moved to suppress everything from the geofence warrant. The district court denied the motion. The Fourth Circuit panel affirmed. The full Fourth Circuit en banc affirmed, in a one-sentence opinion, with 14 of 15 judges voting to uphold the result. The Supreme Court then took the case, but only on one question. Did the geofence warrant violate the Fourth Amendment? The good faith exception issue, which would block suppression regardless of outcome? The court declined to review separately.
Meaning Chatrie faces prison either way, but the constitutional answer still impacts the rules for every future geofence warrant in America, and now it's at the Supreme Court. Let's get into the arguments. Chatrie comes in swinging with 2 independent paths to a Fourth Amendment violation. Path 1, property. Path 2, privacy.
Let's start with property. Chatrie argues that location history data stored in his Google account belongs to him, not Google. He compares it to papers stored in a filing cabinet. The government accessing it without proper authority amounted to a trespass. He roots this in an 18th century English case, Entick versus Carrington, decided in 1765, where a judge held that a general warrant to seize all of a man's papers violated both his property rights and his privacy. Chatrie says the founders adopted the Fourth Amendment specifically to prevent that kind of warrant from taking root in America, and he has a modern precedent to back it up. In United States versus Jones, 2012, the Supreme Court held that attaching a GPS tracker to a suspect's car for 28 days constituted a Fourth Amendment search because it trespassed on the car. Chatrie argues accessing his Google account, where his data lived, follows the same logic.
Path 2, privacy. Even under the traditional test, which asks whether a person held a reasonable expectation of privacy in the information, Chatrie argues location. History data qualifies. He leans on Carpenter versus United States, the 2018 case where the court held that 7 or more days of cell site location information triggered Fourth Amendment protection because it revealed the intimate patterns of a person's daily life. Chatrie says location history goes even further. It logs location every 2 minutes, precise to within 3 meters, tracking elevation within a building. The most sweeping, granular, and comprehensive location tool available, the district court found. Here's where Chatrie's second main argument arrives, the general warrant problem. He argues the geofence warrant operates exactly like the writs of assistance the founders despised. It directs the government to search first and develop suspicion later. The warrant named no account. It gave no probable cause as to any particular user. It simply told Google, sweep everything, see what you find, then narrow down.
He puts it this way. The government need only draw a virtual fence around a church, a political rally, or a gun shop, and it can compel Google to identify everyone who walked through.
And his third argument takes on each step of the warrant individually. Even if you accept the government's theory that a search only occurs when law enforcement actually receives data, Chatrie argues the warrant still fails. At step 1, police obtained private data from 19 people based solely on their proximity to a crime. That's not probable cause as to any individual. And at steps 2 and 3, investigators narrowed the list at their own discretion with no return to a judge.
He compares that to getting a warrant to search a neighborhood, then freely expanding the search block by block. No new judicial authorization required.
Now the government's response, and it's 3-pronged. The government's opening move. Chatrie gave Google his location voluntarily, so he loses Fourth Amendment protection under the third-party doctrine. This doctrine, established in Smith versus Maryland, a 1979 case, says that when you voluntarily share information with a third party, you assume the risk that the third party will disclose it to law enforcement.
Chatrie enabled location history through 4 separate affirmative steps. He had to turn on his device's location setting, opt into location history for his Google account, enable location reporting for his specific device, and sign into his account on that phone. 2/3 of Google account holders never did any of that.
The government pairs this with United States versus Knotts, 1983, where the court held that tracking a suspect's car across multiple hours of public roads didn't constitute a Fourth Amendment search because anyone could have observed that travel. 2 hours of location data, the government argues, falls squarely within what Knotts permits.
And here's the critical distinction the government draws from Carpenter. CSLI, the data at issue in Carpenter, recorded location involuntarily for every phone, every moment the phone was on. Location history required multiple opt-in steps and affected only 1/3 of Google users. The government argues those differences make all the difference.
On Chatrie's property theory, the government fires back hard. First, it argues Chatrie forfeited the property argument below. The Court of Appeals panel found he never raised it properly, so the Supreme Court shouldn't address it at all. Second, even on the merits, American law doesn't recognize property rights in data. The government offers a razor-sharp analogy from the brief. If a tailor notes your measurements in his files, those notes still belong to the tailor, not you. The word your describes the subject of the information, not its owner.
And Google, the government argues, retained full rights over the sensor vault, the ability to use the data for advertising, to disclose non-personally identifiable information publicly, and even to delete it. Chatrie's supposed property right evaporates against those facts.
On the general warrant argument, the government draws a sharp line between what law enforcement saw and what Google searched. The officers saw 19 anonymized location blips. Google's internal search of its own database, however broad, does not constitute a government search of millions of accounts. The government compares the geofence warrant to a bar security camera. A warrant for the footage is a warrant for particular evidence, not a general rummage through the bar.
And the government invokes Zurcher versus Stanford Daily, a 1978 case which held that warrants can issue to search third parties for evidence of a crime, even without suspecting the third party, and even without naming a specific suspect. Police can subpoena a hotel registry to find out who occupied a room near a crime. A geofence warrant does the same thing.
So, what does this actually mean for real people?
If Chatrie wins, geofence warrants as currently used likely end. Law enforcement would need to name a particular suspect, or at minimum, a particular account, before Google opens any search. That raises the bar substantially for investigating crimes where the suspect's identity remains unknown. And it raises a question that goes way beyond this case. If a person holds a property interest in their location history, does that logic extend to their email, their Google Drive documents, their search history? The ruling could reshape Fourth Amendment protection across the entire cloud computing landscape.
Flip side, if the government wins, law enforcement gets constitutional clearance to use geofence warrants against whatever location they choose. Protests, houses of worship, medical clinics. The government's probable cause rests on geography, not on any specific person, and the court would bless that framework.
For everyday smartphone users, a government win means every opt-in decision carries a new consequence. Enabling location history means accepting that your movement, stored in Google's servers, could appear in a criminal investigation, even if you never became a suspect.
And there's one more twist. Remember, the court declined to review the good faith exception question. 14 of 15 Fourth Circuit judges found that investigators here acted in objective good faith. That finding stands regardless of how the Supreme Court rules on the merits. Chatrie almost certainly stays convicted, but the constitutional guardrails for every future case get set right now.
So those are the stakes. What should we watch for at oral arguments?
Watch for questions about what triggers the search. Several justices will want to know, does a search occur when Google scans its database, or only when law enforcement receives data? That line matters enormously for the general warrant argument. I'd expect Justice Alito and Justice Thomas to press hard on voluntariness. Chatrie opted in. He could have paused location history before the robbery. At what point does that choice seal the constitutional analysis?
And watch the liberal justices on the property theory. Chatrie's counsel comes from Jenner and Block. They'll push the property argument as an alternative ground for reversal. Justices Sotomayor and Kagan have both expressed interest in property-based Fourth Amendment analysis in prior cases.
The fault line might land here. Can the court craft a rule that allows some geofence warrants, maybe with tighter geographic and temporal limits, while still protecting against broader fishing expeditions? Or does the doctrine force an all-or-nothing answer?
And don't sleep on Justice Gorsuch. He authored the dissent in Carpenter that argued for a stronger property-based Fourth Amendment framework. Chatrie's property argument essentially invites Gorsuch to run that theory as the majority.
Bottom line time. Why does this case matter?
Because it sets the constitutional rules for an investigative tool law enforcement uses in thousands of cases a year. and it determines whether the Fourth Amendment protects your location data at all or whether hitting OK on a Google prompt means surrendering that protection forever. If you made it this far, share this episode with someone who thinks Supreme Court cases don't touch their real life. Show them their phone, point at the location setting. This case affects anyone who carries one.
You can find us on Apple Podcasts, Spotify, YouTube. Just search the High Court Report. Follow on YouTube for shorts, and if you have questions about this case, reach out on LinkedIn at the High Court Report. And please follow, rate, subscribe, share, and review on Apple, Spotify, YouTube, anywhere you podcast. Just search the High Court Report.
Seriously, it takes 30 seconds and it helps more than you'd think. Which, as it turns out, is probably longer than it took Chatrie to forget his location history setting.
Talk to you soon.